Hi, my name is Mohammad Alif Siddique. My student ID is 0351948. The question was explain what customary international laws are and discuss its importance. So now I am going to discuss about this question. So first of all is introduction. The term customary international law refers to those legal responsibilities that are part of usual international practices but may not be expressly stated in conventions and treaties. Customary international law is often described as a general and consistent practice of states followed by them out of a sense of legal obligation. Customary international laws were created because of multiple governments feeling a sense of obligation to uphold the law and adopting a general and consistent practice. For instance, until the Vienna Convention on Diplomatic Relations entered into force in 1961, the practice of providing diplomatic immunity was unwritten international custom. By the Gulf of Maine case in 1984 stated that if the specific legal framework of a treaty is not universally embraced, custom is always there to fill the gap. Custom is perfectly adapted to the establishment of broad principles. Then, the recognition of customary international law. According to Article 38, Section 1, Subsection B of the International Court of Justice, customary international law is a usual and universal practice that is regarded as a law. The International Court of Justice is an international tribunal that arbitrates conflicts involving UN members. The international customs and common practices of states are one of the sources of customary international law. According to Article 38 of the statute, and such customary law is one of the sources of international law. Other types of entities such as non-governmental international organizations such as Amnesty International, the Institute of International Law or the International Law Association, multinational and national corporations and even individuals all contribute to development of customary international law. But the behavior that seeks to establish a deviating norm must necessarily be a breach of the previously established norm. It is claimed that old customary law theory leads to the conclusion that change in customary international law is not possible. There are two sources of customary international law. Those are general state practice and opinion juris. General state practice. The state practice must be widely known and consistent. These customs are unwritten and mostly focused on the interstate diplomatic interactions and humanitarian ideals. As an instance, states may offer sanctuary and refuge to those fleeing countries where they fear from their life and freedom. The second is opinion juris, which means to legal opinion. In the simplest terms, it refers to what the states have deemed to be law. Opinion juris is usually referred to as the subjective aspect of customary international law. Opinion juris is typically expressed as requiring that a practice be recognized as law. The establishment of rules of opinion juris are not entirely clear, but the majority conclude that it is necessary in some form. It is one of the factors required to establish a customary law that has legal force. The states legislate some customary practices and recognize them as laws in order to develop unifying customary practices in interstate interactions. According to the doctrine of opinion juris, the states must ratify the law to be obliged to uphold it. Jus cogens. Some rights are deemed to be non-derogable under human rights accords because they are seen to be of such utmost importance. The rights to life and liberty, for instance. Jus cogens norms are the term given to those rights. The norms established by the jus cogens principle in international law cannot be changed. Jus cogens, a Latin phrase, it means compelling law in English. These laws already exist, thus there is no need to codify them. These customary laws have their foundations in the idea of natural law. Any law that conflicts with it must be repealed. For instance, it is against jus cogens to uphold laws that authorize slavery, torture, genocide, crimes against humanity, etc. It should be noted, though, that while all jus cogens are derived from customary international law, not all customary international laws have the possibility to become as jus cogens. These are the fundamental and most significant rules that other laws must be based on. And uncodified customary international law. Some customary international laws are codified by various domestic laws and treaties, while others are not. All customary international laws are recognized whether they are codified or not. Jus in bello or law of war in Latin is derived from customary international laws and was not defined until the Hague and Geneva Conventions. These agreements cannot, in a practical sense, codify every possible legal issue that can occur during a war. As a result, there is a protocol additional to the Geneva Treaties, Protocol 1, which provides that all legal matters relating to an armed conflict that are not covered by such conventions will be handled by customary international law, whether it is codified or not. Though customary international laws require ratification, nation states are not subject to the legal obligations of any international legislation resulting from international conventions unless they have ratified them. However, customary international laws are standards that deal with natural law and humanitarian law and are so commonplace globally that they do not require ratification to be valid. These rules only require states to refrain from passing legislation that conflicts with them, not to specifically use their resources in any way. However, a state may occasionally object to customary international law. In this case, the state is not bound by the law unless it is regarded as jus cogens. The concept of silence implies consent states that laws are enforceable, no protest is raised. This means that if no protest is raised, it is implicit permission to follow such laws. When is ratification necessary? There are several international laws that govern different nation states, but no higher government has the authority to rule these states as its regents. Consequently, the proverb, "the international committee is anarchical," applies. Some nation states, unlike humans, are self-sufficient and don't require anyone else to survive. They have the option to decline the advantages of working with other states, and obligations of being a member of the community is required by law. International law has always held that in order for governments to be bound by a norm, their express permission must be obtained by ratification of a treaty or through some other mechanism. The exception to this rule is customary international law, which is enforceable even in the absence of agreement. Customary international laws, bilateral and multilateral. Bilateral practices between two countries or multilateral practices between more than two countries are the two categories of customary international law. Accordingly, just two nations may recognize a specific custom as customary international law, or customary law may be recognized as such globally. The International Court of Justice acknowledged bilateral customary law for the first time in the case of Portugal against India. In this instance, the court determined that a practice between two nations that both regarded as controlling their relations might serve as a foundation for the development of reciprocal rights and obligations between them. It simply means that bilateral customary international law may later recognize customary behavior between two nation states. Customary international humanitarian law. Customary international humanitarian law, commonly known as the law of war, is a breach of customary law that refers to uncodified standards of public international law that regulate the conduct and legitimacy of armed conflicts. To lessen the negative impacts of conflict, humanitarian law also derives from humanitarian values. To reduce the use of violence, it gives protection to those who are not or have ceased to take part in armed conflict. Since warfare has existed among humans for as long as humanity has, there are several rules and traditions that must be adhered to when fighting. The Hague and Geneva Conventions have incorporated some of these practices and values. Customary laws are still very much applicable in today's armed conflict because it is hard to codify all aspects of legal concerns that might occur during a war, even after such norms are codified. There are many international humanitarian law treaties, such as the Geneva Conventions, that have been universally ratified and are binding on all states. However, not all these treaties have been ratified by all states, and as a result, these laws only apply to the member states that choose to abide by them. This gap is filled by customary international humanitarian law, and even states that have not ratified any humanitarian treaties are required to adhere to certain customs during an occasion. Scholars and nations declare with equal conviction that torture is or is not a violation of customary international law of human rights. That states are or are not accountable for failing to prevent significantly harming another state's environment, and that states have or do not have a duty to fully compensate for the exportation of foreign-owned property under international law. More civil battles and wars for liberation are raging today than there have ever been interstate conflicts. The rules governing international conflicts have been recognized and defined by treaties and conventions, but domestic armed conflicts have less established legal frameworks. In the absence of proper established rules in the treaties and conventions, customary practice served as a guide. International Committee of Red Cross identified 161 customary principles that are relevant in both international and domestic armed conflicts in a study that was published in 2005 by the University of Cambridge in Customary International Humanitarian Law. Although they were not codified, these laws already existed and were enforced by many different countries. This demonstrates that there is mutual understanding both inside and between states. According to the study, states have already determined where to draw a boundary for humanitarian reasons, and they typically don't violate these borders even during armed conflict, even in the absence of the Geneva or Hague Conventions. The analysis also leads us to the conclusion that such uncodified customary rules might spread like wildfire even in the absence of official approval and eventually be acknowledged as customary international law. Then, the importance of customary international law. In 1946, there were 74 independent countries in the world. By 1950, there were 89 independent countries, and as of now, there are 195 independent countries. Following a unified code of customary international law is becoming more and more difficult as independent nations grow. Today, every rule must be codified and expressly ratified to be legally binding. Historically, diplomatic immunity was a fundamental component of customary international law, and there was no need to codify it. However, today diplomatic immunity is strengthened by bilateral agreements, investment, insurance, and other means. We can see that as a state moves from being a custom-driven state to one that follows the law, its behavior pattern is radically changing. This adds a fresh element that tends to strengthen the pattern's stability and dependability. Customary norms are not becoming obsolete, rather all international laws are based on them. The codification of such process guarantees that international law is unambiguous and consistent. Most international laws, however, are founded on customary norms. Although they have been codified for efficiency, these norms nevertheless serve the same purpose. Its conclusion that since there has been humankind, there have been customary international laws. These fundamental principles, which are primarily founded on humanitarian considerations and the notion of natural justice, cannot be broken. While nation-state combat has greatly decreased with the flow of time and technological advancement, and diplomatic ties between states have sharply increased. No state is totally independent due to increased trade and collaboration, and even the most developed states rely on others for various things. It is the codification of these norms and the voluntary ratification by the states that change the way they operate and fundamentally altered the international scenario. Customary international laws have played a significant role in the development of diplomatic relations between states, nation-states. Additionally, it is becoming increasingly difficult to maintain uncodified norms and establish a consistent practice globally due to the growth in the number of states. Codification of this principle was crucial. This is no way implies, however, that the significance of customary international laws has diminished. Customary international law is obligatory on all parties and has a considerably broader range of applicability. They serve as the foundation for all current international norms, and future ones must still follow them.